morning, ladies and gentlemen. On behalf of myself as the Acting Director of Public Prosecutions from Mpumalanga Division, fellow managers, prosecutors, and all support administrative staff in this division, we welcome our colleagues from the National Office who have joined us to present maintenance matters on this webinar. We also welcome all the persons who have managed to join this webinar. Maintenance is a very important issue. Some of the people may be tempted to think that it is soft law because it does not deal with violence like your normal criminal case. But maintenance is an issue that confronts many parents and children. It's a daily issue that they have to live with. It is upon us as prosecutors, in accordance with the duties imposed on us by the we deal with maintenance in our different courts within this province and the stretch of this country. So I'm grateful today that Mpumalanga Division is able to hold this series so that it can inform the public out there in the Mpumalanga province about how maintenance works, what is required when one wants to apply for maintenance, either as a starting point or to apply to increase the amounts to be paid on maintenance if maintenance orders were already issued. I want to also extend a special thank you to all the colleagues within the soccer unit in our province and also to Tuzela care centers who are going to be part of this session. To Advocate Makata, Advocate Kosi, and Advocate Duplessis, thank you. I'm now going to hand over to them so that they can make the presentation and be able to take any questions that will follow out of this presentation. Thank you. I now hand over to Advocate Nkosi and colleagues.
Good morning, everyone. As already indicated, I am Advocate Nkosi. I'm a State Advocate Case Manager. I will be a moderator for today. We are grateful for the warm welcome from our acting DPP. We further extend our acknowledgement to our NDPP, our DNDPP, our Special Director for Public Prosecution, Soccer Unit, as well as Advocate Mr. Nduli, who has already welcomed us. Today, it is our second DPP Mpumalanga Maintenance Awareness Webinar, whereby we will be addressing maintenance issues. There will be a Q&A session at the end of our speakers' presentations. Those who are joining us through Teams will be able to raise their hands and they will be acknowledged in case they have questions, and other questions can also be posed on the chat box. Our speakers for today are Advocate Makata, who is a senior maintenance prosecutor who is also attached to the soccer unit in Mpumalanga. Also Advocate Mdaga, who is our maintenance officer who is under the Department of Justice stationed at Gapogweni Magistrate Court. I will now hand over to Advocate Makata, who will do the introductions for the purpose of the day, who will also tell us more about the importance of maintenance in society as we are celebrating 30 years of democracy as a country. Thank you.
Good morning, colleagues, and everybody who has joined us in this webinar today. And as it has been said by Advocate Ngozi, that South Africa, we are celebrating 10 years of freedom in this country. And we all need to understand where it all started in terms of our rights with regard to maintenance and what is so significant that is being embodied in our constitution. Let everybody remember that in South Africa, as we are celebrating 30 years of freedom, it all started in February 1990 when Nelson Mandela was released from prison. And after he was released from prison, it follows that South Africa, between the period of 1990 to 1993, was engaged in what we call a multi-party negotiations that took place in the World Trade Center outside Johannesburg, wherein these negotiations led to the first democratic elections in this country that took place in April 1994. And it is after the elections of 1994 that our democratically elected government came with the fifth edition of our constitution, the constitution that embodied the rights. And that constitution was promulgated by our then President Nelson Mandela in December 1996. And our constitution, the fifth edition thereof, came into operation or into effect on February 1997. And we should also remember that what is contained in the constitution, there are 5 rights which are very relevant and appropriate for maintenance. That is section 10 of the Constitution that talks about a right to dignity. And when we talk about a right to dignity, it says a dignity of every person must be respected and be promoted. And the second right, which is most important in our Constitution, relevant to maintenance as well, it is section 11 that talks about a right to life. The third one will be section 27 in our Constitution that talks about a right to social security, food, water, and health facilities. And the fourth one will be section 28, which actually talks about the best interest of the child. And the section that is very most important as well, section 28, it says a person is entitled to a family care, parental care, and an appropriate care where a person has been removed to a place of safety. And the last one is being a right to education. So those are 5 relevant and appropriate rights that are being enshrined and contained in our Constitution as we celebrate 30 years in South Africa of democracy. And not forgetting that a Maintenance Act, it is one of the central components that brings in the maintenance regulations and the enforceable penalties that are structurally so embodied in the Maintenance Act that are so strategic that they empower officials to make sure that we paralyze the financial freedom of men who are very recalcitrant in terms of maintaining their children when it comes to the maintenance matters. So with that being said, to me as an opening, I hope we'll all enjoy this. As now I pass to Mr. Mdaga, the Advocate Mdaga, to can take over the proceedings. Thank you. You'll all be pardoned for me because I have a very coarse voice. Thank you so much.
Thank you, colleagues. Advocate Makata, thank you.
Thank you.
I am Advocate Mdaga from the Department of Justice, having to deal with maintenance cases on daily basis. There's a lot of experiences that will come through in the court level. And it's painful to see that there's a very, very, very good need for maintenance and the respondents or defaulters to come to book for not complying with the maintenance obligations. So today I would like to discuss step by step how to apply for maintenance and the remedies available if maintenance defaulter doesn't comply with the maintenance obligations. So at common law, three requirements or three prerequisites were developed for duty of support. And we must ensure that there's a need for maintenance, there are means to comply with the maintenance obligations, and the relationship between those people that need to be maintained and the one that to maintain, it's of such a nature that is legally recognized. So I'm going to discuss this and the requirements when one wants to open maintenance. The Maintenance Act is such a very good piece of legislation, and where it falls short, it's covered by appropriate case law, which have been decided throughout to develop this part of the law. So in most cases, the applicants that are coming to court, they don't know about the jurisdiction, they don't know about the whereabouts of the respondents, and they don't have any information about the financial positions of the respondents. So the maintenance section itself is equipped with personnel from the maintenance officer who's legally qualified to make decisions to enroll a matter or not. There's a maintenance investigator to investigate the needs, the legal duty, as well as the means where can we allocate the respondent, the location of the respondent as well. So when a person approaches a maintenance court, we'll come across a maintenance clerk who will explain the process, how to open a maintenance file. The process will start by us establishing jurisdiction. And maintenance, we should remember that it is a sui generis court. That means it's a specialized court. The monetary jurisdiction of the magistrate court is not applicable in the maintenance court. So the maintenance court can grant an order of even $1 million, because we get such orders when we do the future maintenance, which I'll explain later. So the clerk of the court will explain the jurisdiction, will redirect the applicant if does not fall within the court's area of jurisdiction, and will explain thoroughly the requirements that we need for the maintenance file to be opened. So basically, we'll need proof of identity of the applicant, which will be in the form of an ID. In case of a child maintenance, we need birth certificate of the child, and we need proof of residence to establish jurisdiction where a person falls within that court's area of jurisdiction. Then we need proof of banking in the form of bank statement or a letter from the bank which reflects your bank account. This is for the purpose whereby when we make an order, the money must be paid direct to the applicant's account and not to court. So we'll need also the details of the respondent. In most cases, our clients, they don't know. They fall short of this information for the respondent. So in such a case, we ask the maintenance investigator to do the necessary investigation when it comes to allocation of the respondent. When all of these requirements have been complied with, then the maintenance clerk will proceed to file the application. The application will be brought to the maintenance officer for determination whether all the requirements have been complied with. In such a case, investigation when it comes to location and the financial position will be applied by the maintenance officer to court for us to go to the banks or to other institutions which might assist us with this information.
Sorry, Mr. Mtala, before you proceed, I am made aware that there is a participant on the Teams platform. Her name is Nogutula M. Nogutula M, will request that you mute yourself as there is sound coming from your device, and that sound is disruptive to our media. Thank you, Mr. Mtala. You can proceed.
Thank you, Advocate. So as I was explaining the investigation procedure where the applicant does not know the whereabouts or the financial position of the respondent. That is when the maintenance investigator will come on board with the direction of the maintenance officer. The maintenance investigator will take the file and then go to allocate the respondent and to get his financial position. While we're doing all of this, we make sure that the applicant has already made her case by filing all the expenses and her income is reflected on the court file, so that the need part is covered. Now we fall short of the means from the person we're claiming maintenance from. Maintenance is not only, when we start the maintenance case, it's not only the child maintenance. In case whereby there's a divorce and maybe the High Court or the Regional Court or any other court has made a reference that maintenance should be referred to the maintenance court, then we take that order and then we initiate the proceedings. For the prerequisite for that one will be existence of marriage or the divorce order or a lobola letter in such a case. So that one, any person can apply as long as the relationship can be determined by the law and be recognized as such. So the procedure will be, after all the requirements has been complied with, a directive will be issued by the maintenance officer, who is now sure that we've got a case in our hands. So now the case is half, and it depends on the respondent that we call into court for the case to be completed now. The respondent is called in order to dispute or to confirm, one, paternity or the relation between the respondent and the person to be maintained or the person who's applying. Two, the financial position of the respondent, because we might have investigated and we find that maybe the respondent is no longer employed by the time we or does not have means by the time the matter is brought to court. So the respondent is called to confirm paternity or relation, and number two is called to explain his employment status or financial position. So when a directive is issued, a date is set, the parties, they come to court, they don't meet the magistrate there and then, they meet the maintenance officer who will conduct an informal maintenance inquiry. The informal maintenance inquiry is when the maintenance officer confirms that all the prerequisites have been met. He is the father or they are married and he does have means and he's being told of the needs of the person to maintain. If the respondent does not dispute anything, makes an offer for maintenance, there and then the case may be finalized, because the respondent and the applicant will have to will assist them to draft an agreement, which that agreement will be sent to the magistrate to be made an order of court. That agreement may include cash payments for maintenance or may include contributions in the form of maybe if the respondent will pay direct to the service provider, maybe pay direct school fees, buy clothes, buy stationery, pay for transport, cover the child in medical aid. So the court allows that the maintenance order not only be cash strict, but also have contribution of such. So if maybe they don't agree on that informal inquiry, the maintenance officer prepares the file for the formal inquiry in terms of section 10. The formal inquiry is whereby the respondent brings his latest financial documents, his expenses, as well as any other proof of such expenses. And then the applicant will bring her expenses as well, updated one, her expenses, income, and the child's expenses. After that, the matter will be taken to court. The court in the maintenance matter is active. The magistrate is active, it's not passive. The maintenance officer is there to guard that the interests of the child are taken care of and assist the court in reaching the conclusion. So the maintenance officer will first assist the applicant to put matter before the court. will prove the expenses, how much they want and why. So the why will fall on the expenses. The expense is the one that will cover the why part, and any other income that is assisting the child will be taken into consideration. After the maintenance officer is assisted, the applicant will then shift to the respondent to prove why he cannot pay the amount that was proved earlier by the applicant. So the court will make an order in terms of section 16. This order is different from the one that was done earlier by consent, because this one now is an order which is made by the court, and the court may order that your employer deduct monthly maintenance on your behalf and pay to the applicant. That is called in layman's language the garnish order. So that is the order by consent, section 17, and order by court, section 16. So what happens now if the respondent does not come to court? The respondent does not come to court, and we already investigated, we found that is employed or does have means, and the need for the child is there. So the court will order that the applicant adduce evidence before the court why the order by default should be granted in the respondent's absent, and for how much. So the maintenance officer in such a case will lead the applicant to put her case. Remember now, in this time around, the respondent is not there. He is served, or you are ordered by the court to appear, and he does not appear in court. That does not stop the process of maintenance, because the need to maintain the child is there. And we have been confirmed whether this is the relationship between the person to maintain and the person who's liable to pay maintenance. It really exists and is recognized by the law. In such a case, Section 36 of the Children's Act provides for a presumption that if the applicant could prove that there was sexual intercourse at the time the child could have been conceived, so there's a presumption that the respondent is, or might be the father, or is presumed to be the father of the child. So that presumption gives us a green light to proceed with an order in the absence of the respondent until later. Maybe there may be evidence that is otherwise, then the order can be set aside or varied. So after the applicant has adduced evidence, then the court may order the respondent to pay a certain amount of money by default, and then the order shall be served on the respondent who was absent on the proceedings and be served to his employer. The order by default in terms of section 18 gives the respondent 20 days, after which he became aware that there was an order against him that was granted in his abstention, for him to file an application for rescission or for setting aside of that order, or can be varied. So the respondent in his affidavit, after he files that such an application, he can say, okay, I admit paternity, or the mandate on the court is granted is too much, I cannot afford it. That will be the varying part. Or he will say it can be set aside because it disputes paternity or any form of relation to the respondent. So the court will hear the matter at a later stage, give notice to the person against the person who's in favor of the order to say, come to court. The respondent has now filed an application for variation. Then the matter will be treated as if it's section 16, back now to an inquiry. But in the meantime, the order will be proceeding. It won't be suspended or set aside until it is done so by the court. So those are the three orders which the court may make. Section 16, order by court. Section 17, order by consent. And Section 18, order by default. Before I move on the orders, let me also point it out that an order by consent can be done in the absence of one or both of them in the inquiry. So basically, in a practical scenario whereby a respondent is served with a subpoena that is reflecting a certain amount, for example, 1,000 rand, And then when it's served, you can say, no, let me save time. I'm not going to court. Can you give me an order by consent? I'll sign it wherever I am, and then bring it to the inquiry by any other person, or maybe even the maintenance investigator. That can be done, or even in the absence of both of them. So it's not only when the parties are present before the court. So it can be done like that one. Even if maybe the respondent is in another province, is served, he can simply go to the nearest court or in his office, write an email, I hereby consent that an order be issued against me to a certain amount. And then if the applicant accept that amount, then that communication can be made an order of court. Because if it is done with the purpose and intention of the respondent to make an order. So those are the three orders which I would like to discuss with you. And then enforcement of such orders. If those orders are issued and the respondent does not comply with those orders, the applicant have to wait a period of 10 days from the date on which that order becomes payable. Then we'll approach the maintenance officer, the maintenance court, via the maintenance clerk. We'll file an application for enforcement of the order that was done earlier, or that's granted by the court earlier. That application in the form of J306 will be sent to the maintenance officer, who will decide the appropriate way in which the maintenance should be collected. So the Maintenance Act grants 3 or maybe 4 remedies, and I'm going to discuss 3. The 4th one, I'm going to leave it to Advocate Makata. The Maintenance Act in section 26, 27, 28, and 30 provides for remedy which we can collect the maintenance from the defaulters. Section 26 provides that the application should be accompanied by a bank statement which was earlier given to the respondent to deposit money, or his employer to deposit money. That bank statement is a proof for non-payment of the arrears after that 10 days. So the application is an application in a prescribed form, J306, as well as the affidavit by the applicant to say that so-and-so has defaulted and now is the 10th day and he did not pay, he need to comply with his maintenance obligation. From there, the matter is brought to the maintenance officer, who will decide that, okay, this person is employed. If this person is employed, we can simply order his employer to pay on his behalf. That will be monthly maintenance as well as the outstanding areas which he did not pay. We'll do that in terms of section 28, attachment of emoluments. We investigate, we find out he is employed, then there's no problem. We can order the employer to say, okay, for this month, deduct the 1,000 rand as well as repayment of the areas. Maybe the 1,000 rand be paid in an installment, maybe of 250 or 200 rand, depending what the court will see fit. Because remember, we do have the financial position of the respondent on the file. If maybe the respondent is not employed, then the Maintenance Act allows or provides in section 27 attachment of debt. There it gives us another duty to investigate where can we allocate the money. Maybe the respondent is self-employed, or maybe he runs a business, or it does have money lying somewhere, policies, investments, whatever we find, we can attach the money for that month only. So that is not a future maintenance, but we're going to attach only the month that he did not comply with his maintenance obligation. That is attachment of debt in terms of section 27. Then in terms of section 30. Section 27 provides for a warrant of execution. Warrant of execution It's when we check whether the respondent does have property. We start with movable and then we end with immovable. We ask the sheriff to go and identify the property to be attached, value the property, and then sold in execution to cover the maintenance areas. That one, most of the time, we usually is there, is provided, it can be used, but most of the time it's costly to the applicant. So that is why it's not advisable. We rather concentrate on Section 28 and Section 30, attachment of debt and attachment of emoluments. Section 27 is costly because we have to ask the sheriff, pay the sheriff to go and identify, store, and sell on public auction the property to be sold in order to cover the maintenance areas. So those are the three enforcement mechanisms. One, Section 27 will be attachment, the warrant of execution. Section 28 will be attachment of emoluments. Section 30 will be attachment of debt. So in a case whereby an order is made and the respondent decides, okay, because there's an order against me, I will quit my job so as to frustrate the whole process. The maintenance laws, which includes the Act as well as decided case law, does provide that the maintenance court may attach pension fund or provident fund in order to recover the maintenance or to force the respondent to comply with his maintenance obligation. In such a case, the prohibitory interdict or anti-dissipation order is not found in the Maintenance Act, but it was found on decided cases. The law was developed in order to cover this part of the law, to say that the respondent now quits his job in order to frustrate the maintenance process. He doesn't want to comply with his maintenance obligation any further. So when this happens, the applicant should approach the maintenance court, tell the maintenance officer or the maintenance clerk to say that I'm no longer getting maintenance, or the respondent has now left his job. I saw him, because most of the time they won't know until it defaults that why he's not complying with maintenance. Most of the time they will come and say, I saw him, I think he's got a lot of money. I don't know where he got his money. That is the information that we have at our disposal most of the time. If maybe he continues to comply with his maintenance obligation. So the maintenance officer should investigate those allegations. The investigation will start by asking the employer to confirm proof of employment. The employer will tell us this person is no longer employed. Then we go back to court. We'll ask the court to give us a subpoena to subpoena a provident fund or pension fund of the respondent, to give us benefit statement of the respondent. Then they will give us the benefit statement and an anti-dissipation order, prohibitory interdict, will be applied against the respondent's pension benefits. And then the matter will be set down to court for determination of his future maintenance obligation. He must be brought to court in order to explain how is he going to comply with his maintenance obligation in the future. So an order can be made by the court after few calculations to check whether he's in areas, or even if he's not in areas, the court can still make an order in order to reserve future maintenance. Let me point it out that the law is clear that the maintenance is opened by any person who needs maintenance. It's not only a lady against a gentleman or a child against the parent. It's any person who can prove that the person that you're claiming maintenance from has got a legal obligation to maintain you, and he's got needs, and you've got needs, and he's got the means. For example, a parent can claim maintenance from their child, in bracket, child is any person less than 18 years old. But in this case, when I'm talking about a child, I'm talking about the person is their child, but the person should be an adult over the age of 18. So the relation there is the parent and their child. So that is called a reciprocal duty of support. Basically, the parent should prove that they are in need of support, and that person claiming from is of legal age to work and it's got means and is in a position to support them. That is when you prove the relations. A man can claim from a woman and spouse can claim from another, regardless of gender, as long as you can prove relation and means and needs. As I'm closing, Advocate Makata will take over the other drastic measure to collect maintenance, which will be Section 31 of the Maintenance Act, which provides that if the 3 civil remedies have failed to yield good results, then we can now jump to a more drastic measure of issuing summons. As I conclude, let me point it out that the duty of support does not end within the borders of South Africa only. We also do reciprocal maintenance with other countries, as long as we can prove that there's a bilateral treaty agreement with that country, and we do have proclamation number to claim from them, then we can proceed with the maintenance application. The provisional order will be made by the court in the Republic. That should be confirmed by the court where the respondent currently resides in that proclaimed state. I thank you.
Thank you, Advocate Ndaga. And you'll definitely excuse me for my voice. It just went. We just faded on Tuesday, people, in the evening. So allow me to explain about Section 31. And before I can go to Section 31, Advocate Mataga has indicated that when we make an order, we do make an application that we deduct maintenance direct from the employer. Now, once we have made that, you'll find that in the long run, the respondent dies. And when the respondent dies, in most cases, the human resource department of the employer, where the deceased was employed, they will just request that we hand them over the court order for the purpose of doing a child share portion in terms of the financial benefits of the respondent. And let us face a situation where there is what we call claiming maintenance from the estate. What do you do? The deceased has passed on, and once the deceased has passed on, there will be a need that his estate must be advertised or his death must be reported, so that his assets should be brought in one place so that they should be administered. Now, in that instance, then we are taking law of wills and estates. When we do a wills and estates in claiming maintenance from the estate, this is the process. An advertisement will be done. Let's say the surviving spouse will go to court and then to report that the deceased has passed on, and then he wants to apply for what we call letter of authority in simple terms. And then under the circumstances, the estate will have to be winded up. And then there will be a notice in terms of an advertisement, in a way of advertising on a newspaper. Normally at the reverse or at almost 3 or 4 last pages of a newspaper where you will always see words such as notices. That is where an advertisement for an estate does take place. And that is a period that the estate will be advertised for a period of 30 days. We call it lying in for inspection. That is for debtors and creditors, meaning that every person who is being owed by the deceased must approach within 30 days as that estate is lying in for inspection. And those who are owing the respondent must bring in their application, bring it to the attention of the master that this person has been owing me so much. Then, after the lapsing of 30 days period, meaning that the estate has closed, then that is when the estate will be wound up. Now, once during the period of 30 days, you lodge your complaint for maintenance, there will be a certain amount that will be set aside to exempt the estate from maintenance liability. Then when the estate is wound up, that money will be there for maintenance. Now, what happens if 30 days inspection period closes and then you have never made an application or you never brought in your application there as a debtor or as a creditor? Now, an estate has been wound up, payments that have been done. What you are actually going to do, you will lodge an application against the heirs, people who already have inherited when the estate was wound up. You need to prove what we call undue enrichment, meaning that you prove that they received what is actually not theirs. Now it will be a claim against the heirs. So you must also prove as to how much do you think, or it is an appropriate figure that they have enriched themselves in terms of maintenance and money that was due for maintenance. So that will be the process that one will follow in most cases where you claim maintenance from the estate. With the same breath, allow me to move to section 31 of the maintenance. Section 31 it's a criminal proceedings where one has failed to inform the court that when he was financially viable or having exceeded employment or being retrenched, or he has been dismissed as a result of his conduct, then he used up all the monies, he's got no assets that we can attach. What do we do? Such a person will not be left lingering there. And at the same time, remember, people, that the arrears for maintenance states last up to the period of 30 years, according to the decided cases in terms of law. And according to section 26, subsection 4, we are able to recover the arrears, it says, in terms of gratuity or pension fund or compassionate allowance. So people, when you look the meaning of compassionate allowance, hey, SASSA forms part of compassionate allowance. So if you fail to pay maintenance and you found that you are now a pensioner and then 30 years has not lapsed, SASSA, it falls under the definition of compassionate allowance. So with your SASSA money, then you must make sure that you get something out of your SASSA money to pay those arrears because you're getting compassionate allowance. Now, let us go to section 31. In terms of section 31, if one has to look at part 26 of NPA policy manuals, now this is the one that talks about prosecutors. Policy manual where it talks about prosecution-related orders and procedures. The policy manual says that the prosecutor must at all times adopt a victim-centric approach and must be sensitive when dealing with such matters and to receive priority just like any other matters. If we decide not to place the matter on the roll, the prosecutor must indicate. And the complainant must be explained the reason why matter has not been placed on the roll. And then if matter has been placed on the roll, the prosecutor must read and give instructions clearly so to the investigator as to what is it that is needed to ensure that we are having a pragmatic matter to can secure conviction. And it is through our policy manual that talks to prosecutors that when the matter is on the roll and there is a need for postponement, such matter should not be struck from the roll. The postponement must be dealt with while the matter is still on the roll. So such matter should not be withdrawn. And it is through Section 31. Okay, it is very clear that neither the magistrate nor the prosecutor can write off the arrears or change the order. That is not a maintenance court. It is purely dealing with Section 31. Non-compliance with the court order. Now, what is it that we are looking at in terms of maintenance? According to Policy Manual 26, when it talks to prosecutors, it states there are 3 factors, but I will indicate 2. It says that for a matter to proceed in terms of Section 31, we must be sure as the prosecutors that Section 26 remedies are dealt with. If we never dealt with Section 26, either the complainant will give a hint to say, I don't want Section 26 processes to be followed, I want Section 31 to proceed. So it is very much imperative that prosecutors must know that before we say this matter is Section 31, Section 26 proceedings are being dealt with. That is one way of making sure that we are not clustering and compacting the court roll with things that should have been dealt with, and then they are now time-consuming whilst they are on the roll. Now, once the proceedings have unfolded in terms of Section 31, before I can go there, let me say that what is it that we are looking into when we say this is Section 31? The only defense in Section 31 or in maintenance is a lack of means. Lack of means. Now we need to investigate, because one must understand that in terms of criminal matters, it is the state that needs to prove the case, but not the defense to help the state to prove its case. So we must ensure that all the investigations are being done to ensure that we have a strong case to can secure convictions. Once we have gathered all the necessary information and the investigations are being done and concluded, then we know that we have a watertight case against the respondent. And during the proceedings, you find, let's assume that the accused has been found guilty. Obviously, we will secure a conviction, and then the sentence will be a suspended sentence, because according to the decided cases, it says we cannot give the respondent a direct imprisonment, because the very same children, if we incarcerate him, they will suffer. So we must give him a chance and work for these children and bring money on the table to feed these children. So once the respondent has been given, or accused person has been given a suspended sentence, then the prosecutor must make an application to the magistrate that he requests that the accused person, his matter be referred to the inquiry, and that he should pay his maintenance monies with interest. That is an application that must be made by a prosecutor, that he requests that the respondent matter be taken to inquiry, so that he should pay also his arrears with interest. Then once that has been said, then the matter will be dealt with by the very same prosecutor going forward, because she has knowledge of what transpired in the criminal proceedings. And let's say the court gives a respondent, for argument's sake, let's say the order is 1,000 rand. And the respondent has remained in mora to an amount of 5,000 rand. Then the court orders that he is being given a three years sentence, wholly suspended for a period of 4 years, on a condition that he does not find himself being in contravention of that suspended order or of a similar offense within the period of suspension. And he is hereby ordered to defray the arrears with 500 rand, which means he will pay 1,000 rand as maintenance, 500 rand to defray the arrears, 500 rand to defray the arrears with interest, with effect from the 1st of June 2022, let's say for argument's sake. Now, after an order has been, a judgment has been given, respondent was given a suspended sentence, and then now he fails to comply with that order, he's not paying. Or he pays when and if he feels like he wants to pay. What does the law say? As a prosecutor, that matter will come to you. The complainant will file an affidavit to say the respondent was ordered to pay 1,000 rand, and he was ordered also to pay 500 rand to defray the arrears by the magistrate, and then he has failed to do that. Now, we will take that as a prosecutor, the affidavit of the complainant, together with the court order, and the charge sheet, wherein the accused was found guilty by the court, and attach that together with the affidavit of the complainant. Now, we are enforcing what we call Section 297, subsection 9 of the Criminal Procedure Act, putting into operation the suspended sentence. Now, how does a prosecutor do that? To can arrest the respondent out there, the prosecutor must complete J76, order of apprehension. An order of apprehension, it is that form that will be completed, or it is a warrant that the magistrate, through viva voce or reading the affidavit of the complainant by the prosecutor, that here is a charge sheet, the respondent or the accused person was ordered by the court to pay 500 rand with interest to defray the arrears. And so far, according to the complainant, he is in mora. Now, the magistrate, after being satisfied and having to satisfy herself or himself that indeed the respondent has failed to adhere to the court order, then he will authorize the order of apprehension against the respondent, that he be fetched from where he is, he be brought before court. Now, once that has been done, with an order of apprehension has been brought before court, what the prosecutor must do is that he will make an application to court to can put into operation the suspended sentence. Now, the proper way is that this is not having to have this 297(9) section into effect. Does not come automatic. Does not come automatic. What must actually happen there, it will be sort of an inquiry. Pardon me. The magistrate will have to find out the reasons why, because there is a decided case to that effect, State versus Pulse. It is one of those cases that talks to the magistrate that the magistrate must exercise their own discretion when they put into operation the suspended sentences. And once that has been done, then the court is satisfied. Once an inquiry has been done in terms of Section 297, subsection 9 thereof of the Criminal Procedure Act, and the inquiry has been held, then the magistrate will decide whether to put the suspended order into operation or not. And when he decides to put the suspended order into operation, then the accused will go and serve his terms. And if the magistrate does not enforce the sections of section 297 that the suspended sentence be put in operation, there will be reasons, and once the magistrate is satisfied, then the magistrate can decide that the respondent or the accused person does not go direct to imprisonment to serve the suspended sentence. So with that being said, that brings us to the conclusion of my presentation, and I will at this instance take the proceedings and back to Advocate Nkosi.
Siyabonga kakhulu Advocate Makata. Siyabonga futhi ku-Advocate Mdaka ngalolu lwati lenisiniketele lona namuhla. Siyathemba sifundzile kakhulu bekunene ukuthi akunakubaleka ka-maintenance and akusingimake wezintwana kuphela nonga-claima for i-maintenance. Anyone can be an applicant as long as you meet the requirements to go and apply for i-maintenance. Siyathemba ukuthi sitawugwema lo ukuthi sibhadale ma-areas e-maintenance ngemali yempesheni yakasasa. Ngoba 30 years is a very long time for the areas to be active. Siyabonga kakhulu. Labanye ama-questions for now. We can take a few questions, and those questions will be answered by our advocate here.
Okay. We have one question here. It reads as follows. It's coming from, okay. So since there is inflation, if you get a maintenance order of 1,000 rand a month in 2015, the maintenance has been paid for without default. Doesn't that money increase on a yearly basis since things are expensive? School fees is increasing, bread amount is also increasing, and so on. So that's the question coming from one of our participants.
I don't know who will give us an answer. Advocate Mdaka, can you take that?
Okay, thanks. With the maintenance order, it is not automatic that there should be an increase, but it can be agreed on upon making of such an order, that order should be increased at a certain rate per year. If there's no such provision, then the applicant should approach the maintenance court. We encourage that on a yearly basis, because we understand that the person's salary increased once, maybe in a year. So we encourage that per year, the applicant should approach the maintenance court to apply for an increase in the absence of the automatic provision. So in one line, there's no automatic increase. Applicant should not stay for such long time to apply for maintenance, because in such a case, we'll have to see how much was the respondents earning in 2015 and how much is the respondents earning now. So that sequence is missing if the applicant will stay for such a long time. To encourage at least once a year, the applicant should apply for an increase.
Thank you, Advocate Mdaka. Is there another question?
I only have this question so far. It was coming from Kgetole Hotwani.
Siyabonga, Sis Monica Nuswa. I think at this stage, as there are no further questions, we will wrap up our webinar, and we would like to thank everyone who participated, everyone who streamed, and everyone who joined through our various interactive spaces. I will hand over to our acting DPP for the closing remarks.
Thank you, colleagues, for presenting.
There's another question.
Okay.
It's from Nendi Machabe, and then she's asking which maintenance orders cannot be appealed.
Okay. In terms of Section 25 of the Maintenance Act, only an order by the court, in terms of Section 16, it's appealable. An order by consent, Section 17, is not appealable. An order by default is not appealable. So it's only one order by court where evidence was led and cross-examination took place. It can be appealed at a court of higher jurisdiction than the magistrate court. That's one.
Is there another question?
I think there was a pop-up question here.
Oh, yes.
When does maintenance? Did it say when does maintenance stop? No?
Yes. When do one stop to pay maintenance for a child? When does one stop maintenance?
Advocate Makata, maybe you can take that one on.
According to recently decided case, maintenance has got no time frame when one will stop paying maintenance, but it all determined by the facts of each case. What I can explain is that with maintenance, you will find that you are having a child who is actually 17 today, and tomorrow, being the 23rd, she is 18 years. And then on Saturday, being the 24th, that person is now 18 years, and then the father will say, no, umntwana ukhulile, now we must suspend the maintenance. There's no more a need. The law says, a decided case says, there is nothing intrinsic, there is nothing magic about a child attaining an age of majority, being an 18-year-old, because the very same child who goes to school, who you allege to be an adult now, it is still the very same child who does the very same chores in the very same household, who does entirely depends on the mother for ensuring that her necessities are being taken care of. So it all depends on the facts of each case. When can maintenance be stopped to be paid?
Thank you, Advocate. I think I saw another question.
Okay, we have a third question here. It's coming from Tabuti Mamoshiani. Says, morning, I want to know what should happen if the respondent died and his wife received everything from the employer. Then here comes a child and the mother who apply for maintenance against the wife of the respondent or the deceased. What happened in this situation?
Okay, in answering that question, because the father is deceased, now all the monies have been paid out, meaning that the estate has been winded out. It is where the applicant or the person who wants maintenance can bring an application against the person who inherited. By so doing, you will have to institute what we call, or you must prove what we call undue enrichment, which means that you need to compound as to how much you think maintenance was due to a person whom you are applying for that maintenance. So it's a matter of having to get attorneys, and then you lodge a complaint. How do we do this? You start by checking at the master's office whether an estate has been registered. Once you found that an estate has been registered, they will tell you when did that estate went for an advertisement, when did it close, and then when was it winded up, and who is the heir in that estate. Once you have established those things from the master, then you know that you can get an attorney and make an application to claim maintenance from the estate through attorneys, through the process of what we call undue enrichment, which means you need to prove what is it that you think was, or the higher was enriched in terms of the estate monies.
To add, Advocate Makata, basically, when a person who's paying maintenance passed on, the matter now shifts from the maintenance court, goes to now the estate. So the rules of intestate succession will take over there. The maintenance file will no longer be there. What we can assist you with is the copies to prove that the person was maintaining. That is the case where we can go to the estate to prove. But the maintenance file, once the person to be maintained passed on and the person who's maintaining, which is the respondent, passes on, there's no existence of the maintenance file anymore. But if now the applicant passes on, any person who's now the guardian of the child or of the person to maintain takes over, then may approach the maintenance court as long as the respondent is still there and the child is still there. May approach the maintenance court and say, I'm the grandmother or I'm the aunt, social workers or the female advocate is, or the children's court has made an order, the child remains with me. That person can apply for maintenance. But if the child or the person to be maintained and the respondent passes on, then there exists no maintenance file anymore.
Thank you, Mpumalanga. Any other question? Maybe the last one.
Yes, there are two more questions from social media, and it says, when does a criminal case get thrown out or dismissed even after 3 postponements with no witness statements or testimonies? And what can the accused do if they have to keep traveling to attend the court case and it's financially straining or not feasible for them to attend the case, yet the court keeps threatening a warrant of arrest if they fail to appear in court, specifically if the accused is represented by legal aid?
I assume that relates to Section 31, trials or court cases, Advocate Makata.
For a criminal case, Section 31, a case cannot be thrown due to unavailability of witnesses. Let me indicate to say that in the maintenance file, we are having an affidavit of the complainant when the matter goes to Section 31. And then we have an affidavit of the maintenance officer to indicate that indeed he received instructions from the complainant that the respondent is not paying. And I, as a maintenance officer, have requested the maintenance investigator to do the investigations. And I received the maintenance investigator's report on this day relating to the investigations that he has conducted as per my instructions. And there will be an affidavit of a maintenance investigator. After receiving his instructions from the maintenance officer, he will state that I went out after receiving the instructions, that I do investigations on immovables, businesses of the respondent, if any. Then these are my findings. And then he handed over the file to the investigator with attached affidavits. So in the maintenance, when we go for Section 31, we know that our witnesses will be the complainant, who will say, yes, indeed, this person was given an order was ordered by the court to pay maintenance, and he has failed, and he remained in mora up until this period. Then the maintenance officer will come and say, yes, I received instruction from the complainant informing that the respondent is not paying maintenance, and I inform the respondent, the applicant, that I will request investigator to do investigation. Investigator will be there to say, yes, I received instructions, and we investigated to inform the respondent not to be having any immovable properties or any movable properties. Is a man of straws. And then as a result, matter will be taken to Section 31. So maintenance matters, that's how they will proceed, unless he's referring to a criminal case, which I cannot ask. But for maintenance, that is what is happening. That is why even it says in Section 31, investigations when are to be done in the criminal Section 31 proceedings, matter should not be struck off, but then it must be done, investigations, when the matter is on the run. And when it comes to issue of financial implications, it is there, traveling and subsistence allowances. It's applicable to the state witnesses. The respondent, they are the ones who are creating the recalcitrant situation that they found themselves in. So they cannot be at the traveling mercy of, they cannot see themselves to be at the mercy of the state when they are incurring costs for traveling to be in court. And obviously, a person, he's been warned by the court that he should be here before in his next appearance, 8 o'clock or 9:30, as the court will be proceedings from 9 o'clock. So every person in court is being expected to be there either from 8:30 or from 8 o'clock as per court order, or as magistrate will be or would have indicated the availability of any person who is an interested party in the proceedings.
Thank you. There's another question.
And then there's a question from Anonymous. He says, if you were not made aware of the existence of a child for the past 14 years, can you be forced to pay maintenance for the years that have passed when you didn't know about the child?
If you're not made aware of the existence of the child, and then 14 years has passed, so now the applicant applies for maintenance.
Yes.
Maintenance cannot have retrospective effect unless those expenses that you're claiming from are for the laying in expenses of the mother from the time the child was conceived until birth. You can prove with receipts, visits to a guy, that one you can claim. But you cannot now claim maintenance from where the child was born until the child is 14 years old, because we don't know how much were the expenses at the time. We don't know how much the respondent was in at the time, and whether the respondent was working or not at that time. So we encourage that the order should start from the day when the respondent comes to the office to claim, because what we do first, we confirm paternity or relations. So we cannot move any further without confirming whether the child is yours or not. So it will prejudice both parties if maybe the court grants an order with retrospective effect.
Okay, so if it is proven that I'm the father of the child, and then 14 years has passed, and the mother did not make any contact with me, if paternity exists, will I be liable for those years that have passed, or only from
No.
the date of application?
No.
It says maintenance does not exist in a vacuum.
Okay.
Cannot have retrospective effect.
Do we have another one?
Yes.
Probably the last one.
Okay.
It's from Morendeni Mafamadi on Teams, and he says, what are the channels that the respondent can use to notify the court if he or she is struggling to pay maintenance? Yes.
Basically, he should write an affidavit, provide proof, and then submit it to the court, to the maintenance officer at any time. Because just to pick up a phone and phone the maintenance officer or the court to say that I'm struggling to pay. Remember, this is not an installment. This is somebody's meals. This is your obligation, which you are tasked to do. So if you say, I don't have money, we cannot simply just go and tell the child that your father does not have money, so you're not eating tonight. So in short, we're saying you should come to court, you make an application to say that the order which was done against me earlier, I apply that it will be suspended or be reduced or be cancelled in a form J107, that is application for substitution or discharge. So the court needs to make a finding that indeed you are struggling to pay your maintenance, because you can say you are not in a position to maintain, but you are taking care of luxury expenses in the meantime. So basically, you're prioritizing your needs over the child's needs. So the court should make an inquiry and a finding to say, okay, madam, we find that this man is not in a position to maintain. This is his bank statement. This is last pay slip. He's been short paid. He's only got money to to go to work and eat only. So it starts by an application, you call the applicant, the matter goes to court, and then his expenses and income is thoroughly checked.
Thank you. I think in a nutshell, to urge the advocate in Daga is that the respondents must not shy away from approaching the maintenance office should they not be able to provide or to pay the maintenance, because staying away will only cause problems for you. So you should voice out, bring proof to the court to say that I am unable to pay this installment, or if you need a decrease, so you need to approach the maintenance office. Thank you. Are we taking further questions or? Oh, the time, yeah, our time does not allow us anymore. We would like to thank everyone who participated. Like I've already indicated before, that we are very grateful for this opportunity. And as on behalf of our acting PPP, we would like to sibonge wonke umuntu lo-participatile namuhla as we shall close our webinar for today. Thank you very much.
Thank you.